I'm talking about the Supreme Court's momentous decision to overturn Roe versus Wade. And the effect of that is not to outlaw abortion, but to disperse the decision about abortion to the several states. Each state can now pass its own laws. So in a strange way, the court wasn't even deciding the abortion issue at all. What the Supreme Court was deciding is, on this question, who should decide? Should we, the Supreme Court, decide for the whole country? Should each individual woman in the country have their own say? You may say over their womb, and it's like, this is mine. It may be a separate life. It may have its own toes. It may have its own fingers, but nevertheless, it inhabits my body, and therefore I have, you may say, the life or death decision to make over it. Who should decide? And the court basically said, look, we live in a democratic society. When there isn't an enumerated right in the Constitution that has to be protected even against the majority, then the democratic process applies. And that means that states get to make these decisions through a process that will, in effect, reflect the moral consensus, or at least the moral plurality of people living in that state. Now, it's kind of interesting that when I look at all the articles on the topic, they seem to have a kind of erroneous premise. Here's the New Yorker. When the Supreme Court takes away a long-held constitutional right. But it was not a constitutional right. It never was. And that's really Alito's point. Alito says, in a sense, we're not taking away a right. The right never existed. Roe versus Wade was wrongly decided from the beginning. It's kind of like saying the Brown decision in 1954 overturned the right to segregation. No, there never was a segregation right. The Plessy decision going back to the 1890s was bogus from the beginning. Yes, it was in effect for 50 years, but that doesn't put it into the Constitution in any more than an abortion right can be found in the Constitution before. No, it wasn't there before. It wasn't there now. It isn't there now. So that is the key point. And this is even what the dissent ignores. Here is the dissent. Rescinding an individual right in its entirety and conferring it on the state, this is an action the court takes for the first time in history. No, there never was an individual right. The individual right was fabricated from the beginning. Now, the immediate consequence of all this is kind of amazing, and that is that abortion clinics are closing down in the red states. I'm just reading now from Life News. West Virginia is now abortion-free as the state's last abortion center has stopped performing abortions. Confirmed, all 3 abortion businesses in Alabama have stopped killing babies following the Supreme Court decision to overturn Roe. Now, how is this possible? I mean, normally, abortion is now immediately illegal in Kentucky, Louisiana, and South Dakota. How is it possible for a court decision to come on Friday and abortion clinics to be closed, by Monday? And the answer is this. A number of these states had what are called trigger laws. So a trigger law is, okay, you're claiming that abortion is constitutional. There's a constitutional right, and there's a Supreme Court decision, Roe v. Wade, in effect, that declares, however implausibly, that there is this right. We will pass a law so that if at any moment that this right is rescinded or overturned or proclaimed to be bogus by a majority on the Supreme Court, then boom, automatically our pro-life law goes into effect. And so a bunch of states, I believe a dozen or so, have these trigger laws that kick in. They kick in virtually instantaneously, maybe not quite as quickly as the examples I gave. But my point being that these states don't have to go back and make new laws. They've already passed the law. The law is valid as long as it is upheld in the Supreme Court, and that is the case now. Now, there's a bitter backlash, you may say, from the left, and I'll be talking about it in the days ahead. But here I just want to talk about the idea that's been echoed by several people. Even Susan Collins gave it a little bit of rhetorical deference. And this is the idea that somehow these Supreme Court justices lied when they went through the confirmation process. They lied. Well, they lied how? They didn't lie by saying, we're never going to overturn Roe versus Wade. In fact, they refused to answer that question. So you can't say that they lied about that. Well, what did they lie about? Well, they lied about the fact that they said in their hearings that they considered Roe to be quote, settled precedent. But there's no lie there, because that was simply a matter of saying, I mean, if some law, however preposterous, has been in effect for multiple decades, in this case, 40 years, well, 73, almost 50 years, it is settled precedent. It may be bad precedent, but it's still settled precedent. And so I don't think these guys lied. I think what they did is they just played the stupid verbal game of the left. The verbal game of the left is to try to extract from justices statements in advance about how they're going to rule on questions like Roe. And the judges were like, listen, we'll play along with this little, you may call it verbal ping pong. It's just a measure of how degraded our political culture is that justices can't, in effect, say candidly, listen, you lunatics, there's no abortion right in the Constitution. Hold up the Constitution to the light, squeeze lemon juice on it, see if you see an abortion right in it. You won't see one any more than we do. So since you can't be honest and do that, you have these little verbal pirouettes. But when the time comes, the justices ultimately do what they did in this case. They actually looked at the Constitution to see if there was such a right. And in it, they found none.